Good afternoon, everyone. On behalf of Sri Lanka Export Development Board, I warmly welcome you all for EDB's weekly webinar. Today, we are going to organize the 26th webinar in this series. As you all know, our intention is to create awareness among our exporters, potential exporters, newcomers to the industry, about one of the aspects of international trade through this webinar. Today we have selected yet another interesting topic, improving the quality of a product or a service with a successful brand name, filing a registrable mark or a brand name. So you can see that from the topic itself, what we are going to talk about today. It is very important for any exporter to think about your trademarks, patents, registration of brands, which are going to convince your buyer about your product, quality of product. So it will boost your company income, and you can get more demand for your product and the company. So as you know, this webinar will be conducted in two parts. First, our resource person will talk about the topic through using a PowerPoint presentation. Maybe it will take about 50 to 55 minutes today, where we are going to discuss a very vast area today. And then we can go for the Q&A session. Participants can send in your whatever the clarification you want to get from the resource person using the Q&A option in this Zoom application. Depending on the time, we will try to get as much as possible clarifications from our resource person. And we are hopefully we are scheduled to conclude at 3 p.m. However, since there were some technical issues, we can take some more minutes to finish the presentation or the session today. Maybe 15 minutes we can take more than scheduled time. So now my present task is to introduce our resource person. We have invited an eminent speaker who is a very relevant person for the topic, none other than Mrs. Geethanjali Ranawaka, Director General of NIPO, that is the National Intellectual Property Office of Sri Lanka. She will give you the details about this topic, but as I already informed, it's a vast area to be covered, so she will arrange it according to the time limitation as well. So Mrs. Geethanjali Ranawaka is the DG of NIPO, and she's attending at law, and also she holds a Master's of Law degree from Faculty of Law, University of Colombo. And Mrs. Ranawaka has over 27 years of experience at this IP office as an executive officer. She has been serving as the Director General of NIPO since 2012. And also she has knowledge and experience in IP promotion and policy development activities and international relations. So with that introduction, I would like to hand over the floor to Mrs. Ranawaka to make the presentation and create awareness on this topic. Over to you, Mrs. Ranawaka.
Good afternoon. Good afternoon. I think since we have passed our time also a little bit, I would like to move straight away to the presentation. I think all of you who have joined here are welcome to this. Welcome to hear this. Watch this presentation about IP and also especially on trademarks. I am thankful to EDB for inviting us, NIPO, to present a presentation on IP. So I thought it's best to select specifically the area of trademarks, which you know generally as brand names, so that you will have a fair idea how to file an application here, overcoming the difficulties, that is because some of the applications get rejected due to certain defects in the applications formalities. So therefore, those things also I want to highlight here so that you will learn a little bit before you come here to file an application. So let's move on to the presentation. This is you know very well our office, National Intellectual Property Office of Sri Lanka, a department functioning under the Ministry of the Ministry of Trade. Earlier we were under the Ministry of Science and Technology last year, and now under Ministry of Trade. This is the only department in Sri Lanka to administer and control intellectual property rights. So every country in the world over has an office, mostly the government departments, to manage and administer intellectual property. Same way we also have our office here in Sri Lanka. So let's move on to the next slide. This is the title, Improving the Quality of a Product or a Service with a Successful Brand Name. Whilst going through the presentation in general about IP, I'll move fast on to this particular slide where you will see a trademark application form and how to fill it up without making mistakes on this, and also some successful trademarks which have been registered, which are registered with us here, and also a couple of cases also I have highlighted here, and in general trademarks, patents, copyrights, and designs also I'll be giving some details, very brief details. So let's go to the other slide to show you the details. Content is this. These things I think you will get the presentations from EDB, then you can read and learn a little bit by yourself without wasting time here on those things. I will go move. So this is the office, and this was established in 2000 by 2003 Intellectual Property Act number 36, and before that there was Code of Intellectual Property Act number 52 of 1979, under which we were formerly known as Registry of Patents and Trademarks, same as the UK office name, and we started our operations as a separate department in 1980 under that Code of Intellectual Property Act. Prior to that, we were following the British laws here in Sri Lanka because we were a colony since the British colonial period. So thereafter only our separate law was introduced in 1979, and also thereafter with the accession to the TRIPS agreement of the World Trade Organization, we repealed the 1979 Act and we came out with a new Act 36 of 2003. Now we are functioning under that mandate. So these are the functions: administration of intellectual property, collection and dissemination of information, awareness raising, promotion of use of intellectual property in the economic development. All these are our functions, and also that is registration of IP. There are three areas I will show in the next slides. And the fourth area is copyright, where you don't need to register, but you automatically get the rights, copyrights, by creating a work and publishing. And there is another mandate that is to register intellectual property agents. The lawyers, law firms are registered with us as intellectual property agents, and if you browse our website www.gov.lk, www.nip pos.gov.lk. Just type NIPO, then you will see the website. So you will see all the application forms, details, and currently what we have been doing during this COVID period. All these are given in our website. So so you should know what's intellectual property. That is referring to creations of the human mind. Whatever that you create using your efforts and using your brain, knowledge, skills, everything coming together, you come out with a good creation. And when you get legal rights over it, it becomes an intellectual property. So what happens is a party who has created something should run to the intellectual property office to register their intellectual property so that the protection is secured through a registration system. So this is why an intellectual property is established so that any person who comes out with a creation can seek protection under this intellectual property law. Almost all the countries have almost more or less a similar setup in intellectual property laws. Then I will show you some of our two categories under intellectual property, industrial property and copyright. Industrial property and copyright. There are two categories under intellectual property. So industrial property means patents, trademarks, and industrial designs. So these are the three main areas currently we are working on. They are known as industrial property because they are used in the industry, and also these names, that is patents, trademarks, designs, geographical indication, they are all covering a full protection to a certain type of creations. So you will see when you are moving to the next slides how we are granting these protections to intellectual property. First part is industrial property. Secondly, there's another notion called copyright category. Copyright is the right given to literary and artistic works, including computer software that you very well know. They are also not protected under patent but copyright. And it is also known as a creation under literary and artistic work. So under copyright, along with copyright, there is another protection given under related rights. That is called, also called Trademark Rights. In Sinhala we call it Asanna Himikam. That is the rights relating to performing artists and also producers of sound recording and broadcasting organizations and their creations. That is, performing artists are singing, dancing, presenting. They are all are presenters, performers. Their rights are known as related rights. Others are producers of sound recordings, and also our TV channels and broadcasting organization, what they create to telecast and all that are protected under related rights. So you can see the areas, the main areas that we are working on under the Intellectual Property Act. Now here there are three areas which I have given. If you can't see or hear, let me know, because I can't see anybody here. Let me know if there's any difficulty in hearing or seeing me, seeing my presentation. So this I have given a few here under trademarks. Now see what we have registered here, the famous pure Ceylon cinnamon owned by our own EDB, our host here. The Dilma mark owned by a local Sri Lankan company, Dilma. BMW, that's an international mark, very well-known vehicle model. And this is Cargill's Food City, and also Way Home, that is also Slogan. These are all registered with us, and we have about 100,000 marks registered here or sometimes pending. So these are only a few. So the other one is the patent that we have highlighted here with some pictures. You can see multifunctional oral cavity mouth gag. The details I'll be giving in another slide in my presentation. That's a title. Here another live line inspection robot for 33 kV tower lines. And that's the patent number 2249. And another one, toe operated prosthetic hand, patent number 19590. So you can see what we have done here. We receive patent application, we examine, and if the patent, this invention has not been invented by another person earlier, another company earlier in the world over, we look for the world over prior art, we will grant it to the applicant. So for that, we have to go through a very comprehensive, complicated process. So thereafter, only this certificate will come into the hands of the patent applicant. So it's a bit of a cumbersome process than filing a trademark application. So I will not go through a lot on this patent area because it's taking a long time. Then the third part is industrial design. You can see a shape of a bottle, shape of a furniture, shape of all the products that we use in our day-to-day life are all designs, starting from the toothbrush, toothpaste tube, then the comb, the handbag that you use, the shoes, all these are special designs. Some have won the world famous, people's attraction because of their special design, special appearance. And also, along with that, there are other intellectual property rights like the famous brand names, like trademarks, right? So as you know, you call them brand names, we call them trade names because it's the same. Because in order to register a brand name, you have to file an application here and it becomes a trademark. So you generally, in your normal parlance, you call it a brand name. So like this, all these are connected together because if you create, say for example, multifunctional oral cavity mouth gag, that is a gadget used by a veterinary surgeon when he is treating an animal. So, the picture shows an elephant actually. For a dog also it can be used so that he will not bite, he will not harm any person who is trying to treat the animal. So then it's a safety item and it is a very good invention. So these are creations, but when this patent owner gets a patent, he goes out to the market with the gadget. And how does he sell it or trade it? He can't be keeping it in a supermarket and give a packaging, but without identifying that it is his own product and the details, how to use it and all that, those details, he can't sell it, he can't market it. So this is why he should be selecting a brand name as well, that is a trademark. So then he has to file a trademark application here and gets his brand name or trademark registered, so that the people in the who wants to buy this kind of stuff will look at the brand name and will compare it with another one, distinguish it, identify it, and if he likes this particular item, he will buy it, so that he has some kind of sign or logo or a word identifying that product, so that he can select the product by identifying through that trademark. so that he can buy this item. So this is why we say you create it, maybe a patent, you get a patent, but you need to get into the market. For that, you identify a good brand name, good trademark, so that you penetrate into the markets. So this is how we call the brand names are giving you a quality and enhanced protection, so that uh, the market, the consumer will see you as a very successful owner of a brand name, and also they will emotionally get attracted to the mark. That is, they continuously use it and they get attracted to it, and then they will always select it. So that is how you will enhance your protection and also the quality of your product, and day by day you can improve. And also you will not allow a third party to misuse by registering a proper trademark or a brand name, and identifying yourself along with the product in the market. So let's move to the other slide. Then after trademarks, I am moving on to geographical indication, which has been under discussion in the recent past because of almost all traders, exporters in the spice industry are waiting for this particular area to get improved in our system called registration of geographical indications, so that you will get the parties who are trading with the Ceylon tea, Ceylon cinnamon, or Ceylon coconut, they can go to the international market with a special protection than the trademarks or the certification marks that they have already received with this protection, so that it will be recognized more in the world over. So that because the Ceylon tea name will have an identification of the country Ceylon, that is Sri Lanka, the origins, and also the product, the Ceylon tea, will have a quality that is identifying the geographical indication, that is where it is grown. Now, let's say it's grown in Ceylon, it's Ceylon tea, but sometimes it may be grown in Aurelia, it may be grown in Uva, so it has a special taste. Then it is again a geographical indication, and they can go ahead with the registration Uva tea, Aurelia tea, or let's say low country tea. Like that, there are special geographical locations which are giving out this quality product. So then the taste, aroma, and also the quality comes from that area where it is grown. The Ceylon cinnamon is also same. So Ceylon cinnamon has a very good demand in the world over. So when it gets the geographical indication registration, it will have a better protection. We hope to go ahead with this during this year. And the other, finally, I told you, other than industrial property, there's another area of copyrights and related rights. So you would see the books written by an author is protected under copyrights. Now here, the Mr. Martin Wickramasinghe's late Mr. Martin Wickramasinghe's Madolduwa and late Mr. Mahagamasekara's songs. This is taken from the websites that is uploaded to the website by them. Original songs written. These are all copyright protected. And see in the translations. That's a translation that is also protected work. These are all protected work which has copyright, and it's 70 years, lifetime plus 70 years for it's protected for lifetime plus 70 years. So these things need more details. Actually, there's no time to tell all these things. Yeah, again, the related rights are performing rights, as I told you. A singer or a dancer or a performer, when they perform, from there on, 50 years, the protection is allowed under the Act, under the law. So therefore, all these are protected under related rights, the performers' rights. So then, these things will need more information for you to understand if you want to know about copyrights and related rights. So let's stop from there and go to our subject, that is registration processes here. First, I have given here general system that we do here. We get the application, we do a formality examination, then a substantive examination, and we do a substantive examination using the local and international databases. And then if the mark or if the invention that somebody has created, uh, uh, somebody has filed the patent application, we do this search in this manner. If they are accepted, we have to publish in the Gazette, Government Gazette, and allow a third party to file objections, and then we grant a certificate, maybe a patent document, patent certificate, or a trademark certificate, or an industrial design certificate. As I told you earlier, for copyrights, there is no registration system here. The protection starts to work automatically by operation of law. So let's, this is the, I told you, granting a patent is a cumbersome process. If you are interested, you can read this flow chart and see when you're filing on, you will want this detail actually. Otherwise, this is just for our purposes. We have prepared this. What we do here, first the formality. Once you file an application with the fee, formality, then substantive, and then if there are defects, we have to send back to the applicant, asking them to correct the defects, and then if the amendments have come, or if the corrections have been done, or if all defective documents have been corrected or replaced, we go ahead with the registration process. Prior to that, we publish it in the Gazette and leave it for 3 months, calling for objections. So like that, that's the process. Now, our important part is trademark examination. As I told you, I'll jump over to this particular slide. Now see, this is the trademark application form that you would see if you browse our website, form M1. Now see, we ask for details like, first of all, your applicant's name. Now, before you start filing an application, you need to select a very good trademark. This is why I made this title as how to create a registerable trademark, right? A brand name. You create something, but it will not be a good trademark unless and until you follow a certain process and also select a quality, distinctive, unique mark for your own company or for your own self. That is, even an individual can file an application. And also, you must remember, filing a trademark application is not compulsory. You can even start entering into a market without registering a brand name or a trademark. But in time to come, when your product becomes popular and the customers start purchasing them, only you will realize the importance of the mark, because by the time you get popular and the people are attracted to your product, another third party will try to copy your mark or infringe your mark and file an application here prior to you. So therefore, the moment you start working on a product, say you are going to start a tea packing tea manufacturing, tea packing industry. So first you will buy, purchase maybe from or tea auctions tea, and you bring it, and then you have a place to do packing and all that, and then you have to label it. And when you go for labeling only, you will realize you need a identification for yourself, your company, to identify your product. So what do you do? This is why we say you need to select a good trademark so that you can register it with us, and you can allow the people to identify yourself by way of that unique mark or slogan or whatever. So this is why we say a trademark distinguishes your mark from another mark in the market, and so that the consumer will select your mark, your product, using that particular unique mark that you have registered and published by using it in the market on your products. So this is why sometimes a certain word mark along with the label and a colorful depiction, all the things are called composite mark, and then whole thing will be considered as a unique trademark for you, a unique brand name. Now, for example, if you are thinking of well-known marks here in Sri Lanka, say Singer. So Singer has been here for some years, for long years, and it's an international mark. So locally also people know the mark Singer. So you don't have to do many things to get publicity for that mark, because already it's known to people and it's well known. So but when you are coming out with a new mark, you have to be very careful, because there can be infringers, there can be other parties who will use your mark and try to manufacture products under that particular and your mark without coming out with their own mark. So the point is, they will file an application here also to register that mark of yours, because you have not come here already to register it. So this is why we always advise applicants to come out with a good trademark and come over to our office and file this application. Now here comes the details, formalities. Now the applicant's name and address. Now here, if you are a company incorporated here in Sri Lanka, you have to give the details here, incorporation, incorporated and all that. Details should be given, private limited or whatever, PLC. Or then if it is an individual, your full name has to be given here. ABC Pereira or whatever. Then we ask AB, what stands for ABC. Then you have to give the full name. If it's a partnership, then there are 2 partners, 3 partners. All the names of the partners have to be given here, and trading as this partnership, that you have to mention here. Because when we are granting a certificate, it will be for all 3 partners. The ownership goes to all 3 partners, right? So you have to, because the ownership is shared by these 3 partners, all 3 names have to be given, and in the certificate also, we will be giving the 3 names, so and so, so and so, so and so, A and B and C, trading as ABC company. So that's a partnership. So the whole thing has to be given here. Otherwise, we will inform the applicant that this is defective and you need to correct this if we see these things. And at the counter here, public information counter, we advise applicants to get these things clearly written, especially if they are going to use handwritten application, write in block capitals, right, block letters, because sometimes when you're entering it into the system, we cannot identify sometimes eligible, not eligible, the handwritten application. So we ask them to clearly write the names, addresses and details in this application in capital letters. So then the address should be given clearly. Whatever the address that you are using in this trade, in this business. Now, supposing you are having the business in Colombo and you are living in say Badulla, sometimes you will, because you are filing it in your individual name and you are giving the Badulla address. But you will be your trading or manufacturing or are being done, trading done in Colombo. So what you should do is you should be giving your Colombo address, because when you are in a business, you will not be doing that in Badulla, your home address. You will be doing it in Colombo because your office is in Colombo. So if you give the Badulla address, we will be sending all the letters to Badulla address. What happens is, if you are not there continuously living there, then the letters will not come to you. What happens is, then we have to wait until you respond, and if you don't respond, we can close the files by informing you that the file will be closed or treated as abandoned because you have not responded our letters. So therefore, please be mindful to enter the correct address where your business is, or even if it's an individual name where you are continuously living, because it becomes your postal address as well. Should be, because we are serving the letters to the postal address. This address and the address that we are asking on the next page as the postal address to serve the documents should be identical, then it's easier. Now, there is a situation where there are international applicants. Now, if there's an applicant from Japan, that applicant's company name and the address should be given in this applicant format. This is applicable to IP agents in this matter, because this Japanese applicant will have to find an IP agent here in Sri Lanka to file this application, and he will have to retain this IP agent to file this application in our office. So therefore, his name and address should be given here, but the IP agent's details should be given in the next page as the agent's details, so that all our letters will go to the agent, not to the address given there in Japan, because we are not dealing with international applicants overseas directly. We deal with the local address only. So therefore, that has to be kept in mind. And thereafter, we are asking for applicant's name, details. Now see, if the mark has colors, the colors could be claimed here, because some marks are identified by color combinations. Now, if you look at Coca-Cola, the red and white is a unique color combination which they have kept all along as a unique trademark along with the colors. Therefore, color claims can be sometimes very useful if you claim and use it, so that your product will be identified by the colors as well, not only the mark. Now, supposing sunlight mark, just come to your mind, right? The wrapper, we use it. It has yellow, blue, and some small parts in other colors. But yellow and blue is a unique color, which is given. It's a combination, and that image is, image is always in our mind along with the two colors, right? If it comes in a different color, of course, we will look at it as if it's another brand name, right? Because we are used to use that two color combination, and they have registered with us. The Unilever has registered that sunlight mark with us with the color claim, yellow and blue. So like that, claim to colors are also very important. And thereafter, there's another area where we are asking whether there's a dimensional mark. That's a bottle or something, and there's a shape that, if of course, is not relevant to ordinary marks. And the other important area is list of goods. What are you going to claim? Now, if it's a personal care product, then it comes in the international class 3, like soap, perfumes and all that come in class 3, and then tea, rice, flour, and all those products come in class 30, and yogurt and all these jellies and fruits and the fruit related products come in class 29, and the drinks, cool drinks, soft drinks, mineral water, and all those come in class 32. Like that, there's a list of classes up to 45, from which you can select whatever the goods that you want to protect, and you have to identify them here. And all these can be information can be taken from our website, and also there are international classification details also given here. You can also browse them and see. And apart from the goods, there are services starting from advertising in class 35, and also transportation, hotel and restaurants, professional services, like that. There are up to 45, there are classes, and you have to mention all those details in that cage. And this is a priority claim. That is, if there is an international application which is claiming a priority, 6 months priority can be claimed from another application filed before in another country. Those details need to be mentioned here. This is applicable to international applications mostly, and those details should be given here, and they have to file authentication documents attached to the application. This can be done through an agent, because the international applicant has to come through an agent. The agent has to handle all these things in our office. So then the signature and all those details need to be given in the application. You will see, you can get a full application form from our website and see other things. Now, if it's a company, then the director's signature should be there in the application, signed by a director. One director's signature is sufficient, and the seal has to be placed. And if it is an individual, the individual signature has to be placed at the end of the application. And if there's a partnership, the partner's signature should be there. If it's an IP agent who is filing on behalf of an international applicant or a local applicant, even a local applicant can retain an IP agent, so that his task is much easier, because he doesn't have to send his own company people to our office to file this application. He can retain an agent, then the agent on behalf of that applicant can file this application. And when the agent is filing the application on behalf of an applicant, agent's signature can be placed. So for that, they have to support it by a letter of authority or a power of attorney as required by the provisions in the Act. So these are the formality details which are required by the application. And now I will move the certification marks and collective marks. These are also more details about marks. Sorry. And what we do once we get a application along with the fee, we ask you to file the application along with the fee. Individual has a different fee, and company has a different fee, 3,000 something, and then for a company and a local 1,100, that is with the tax. So therefore, you have to identify from our list what type of fee that you have to pay. Along with the payment slip, you have to file this application. Now, currently, we don't entertain any applicants here because due to the COVID situation, you can do this online by sending us an email along with the payment slip. The application can be scanned and sent. Now, see, when we receive the application, we check the formalities that I explained earlier, and thereafter, what we do is we do the substantive examination on the application and see whether the mark that you selected is a registerable mark. So for that, we need to go through two sections. There is section 103 of the Act and 104. And there are requirements. Now here I have given the requirements which are very simple. If you go through, you can understand. Sorry. Which consists of shapes or forms imposed by the inherent nature of the goods or services or by their industrial function. If it's a mark in that form, in a shape, then we will reject it because it will not identify your product as a unique distinctive mark. For example, you will if you are manufacturing, say, you are in a ceramic industry and you come out with a plate, right? The plate is ceramic products, right? Now, if your mark is a device, a logo of a plate, right? So there is no mark there. So we will definitely reject it because there is no identification about your identity, so that a person could identify or distinguish your mark from another mark. So this is why we ask you not to file that kind of mark for registration. Now then we look at the mark so that we examine so that the sign or the mark is not a descriptive one, describing the kind, quality, quantity, the purpose, value, place of origin, all these we look at it, and then most of the time we reject applications under 103(1)(b) or D, right? B means describing your mark, your own mark. Now see Ceylon tea, right? And then pure Ceylon tea, or sometimes this is our daily tea. Our daily tea. There's no mark there. Just a few words, English words. Then that's describing the goods, right? So therefore we reject it under this section. So then there's C. You can see a customary designation of goods, which is also not applicable, registerable easily. Then the D, section D, 103(1)(d), incapable of distinguishing the goods or services of one enterprise from those of another enterprise. This is a very important section where you can't come out with a mark which is not identifying your product, distinguishing your product from another product. So therefore, you must not have any close resemblance or your confusion with another mark in the market. So because you need to have a distinguishable unique mark on your product. So these things also, when we just explain, you can't understand, but when you look at our system, you will understand what we mean by this. It should be a very distinctive mark so that it will go up to the registration. Now there are so many other things like, the logos or signs which has scandalous designs, that is religious susceptibilities. We don't accept the cross device, Dharma Chakra device. We always reject them because it's a scandalous sign. And also any confusion as to the source for the geographical indication. Like if it is, say, now you are trying to sell a local product and you say London tea, right? Then it's a wrong indication about the source, right? Then it's not London tea really, you are trying to sell a local product. So what's the use of coming out with London tea or Bahamas tea or whatever, right? So you need to intelligently select your own mark. This is why we say look at these sections. You can look at our systems and see what kind of distinctive marks you can come out with. And there are other things like flags, emblems you can't use of government organizations or NGOs or government emblems of any nation, flags. So that these things, if you avoid, your application will go through the process of registration, and you can easily get a registration from us. And here again, the geographical name or surname means very common surnames we don't allow. Geographical names also we don't allow. If you say Sri Jayawardhanapura Kotte as a mark, we will definitely reject because it's a well-known geographical name. And also a surname, very well-known surname, if you use, again, we refuse it, right? Because no one can get exclusive right to a surname. Maybe the first names are okay because if first names can be used in a product and if they can show that it has become a unique one, then no problem, right? So therefore you need to select them so that this refusal under objective grounds can be can overcome these refusals, right? So then these you can read. And also there's another subjective grounds refusal where if your mark is similar to a mark that has been filed with us in our office by another party, if it is slightly similar or exactly similar, then we will definitely reject your application and you will have no chance of proceeding up to registration because you have tried to copy somebody else's mark and come into the picture, come into the register, and you have not come out with a unique mark. So this is why we keep it. And most of the time, if locals are trying to copy the international marks and come into the picture, we look at our database as well as the global database, and if we see and there's an international mark which is well known and we and may not have validity now in Sri Lanka in still, but it has been there for a while and not continued use, or sometimes filed and filed later but priority claimed. Like that, there are various ways an application can be registered here. So the second application, which is similar to that, will be rejected. So these things are more details. And even if it's an unregistered mark used earlier, and if someone is filing here an application similar to that, then again it will get rejected. And also trade names used by a third party. If another person is trying to register it here in our office, then it will get rejected. So you need to be careful not to go into other people's territories. You have to select a unique one. Then well-known category, we look at the marks to see whether they are well-known. Well-known means now I can mention, say, McDonald's. The mark McDonald's is well-known for restaurants and food parlors and fast food parlors. So if someone is trying to use at least part of it and come out with another mark, it will definitely get rejected because that mark will get rejected. First thing, because 101A, because McDonald's is already registered in Sri Lanka with us. Secondly, even if it is not registered, it can be rejected under this category as well, well-known category, because we are supposed to look at that and allow parties to come out with unique distinctive marks without using well-known parts of well-known marks or well-known mark, because it's an infringement of another person's rights. So these are the details actually, and also these things finally come to a prevention of unfair competition in the market. When you're using a mark, it should not be unfair competition. It can be competition, but not unfair competition. So you should be in the market together, but not competing unfairly. So these are the sections, clear section that we are looking at. And these are all you can read and see. I am not going to spend the time on it. And unfair competition, I mentioned just here, any act or practice carried out or engaged in the course of industrial or commercial activity, that is you are in business, that is contrary to honest practices shall constitute an act of unfair competition. However much you try to prove that you were honestly trying to compete fairly, if you have taken over another person's mark, a part of a mark, and trying to market it and trying to register it, then you come to this category and your application will get rejected. And also, even if you have been able to register here, for some reason, say we have made a mistake and allowed you to go ahead, whilst you are in the market, that party who is having the original mark with us and also in the market will file an unfair competition action against your application in courts. So therefore, these things need to be kept in mind when you are proceeding with your application. So these are more details about our sections. You can read our act and see. Now see some of the marks that we have registered, and I think we are passing the time also, but still I'll there are a few more slides which are very important. See the marks, some of the marks which can be considered as unique ones, registerable ones, right? Different marks. See how they have created by using different fonts and effects, looks, colors, color combinations, and artistic way of presentations. So we are very happy to receive this kind of application because it shows how creative people can be without going into the territory of other people's marks. You need to create your own mark with color combinations which are eye-catching and also attractive and also won't get rejected here. As I showed you the sections, how many things to look at before registration. So therefore, you need to be careful without infringing others' rights. You need to file these applications, and for that we allow you to log into our web database by coming here and look at the system and see whether there are similar marks which you can infringe if you file certain marks. So therefore, that is allowed, but these days there's difficulty. But in general, under general conditions, normal circumstances, you can come here and look at our system. Now see marks consisting of descriptive words, but admissible for being creatively presented. Now see, leaf and cup. Now see Aralia. Island influencer. Right? Cinnamon Bentota Beach. Now see that logo. How nicely it's presented. Right? So these are certain marks. Now sometimes the creativity is there. From that only they have been able to proceed with the registration easily. Now these are very well established marks. It has been there for a while. The General Electrics of Electrics mark GE, how they have presented the letters, and see another one, a local application, path, how it's presented, how creative, and so these have no distinct element, but the presentation in fonts is creative. But see, nothing much on that. Ceylon rose, Ceylon cinnamon, Ceylon sandal, Ceylon jasmine. But Ceylon cinnamon has a protection because its uniqueness about the geographical indication. But otherwise, these are all common terms. Now see, single distinctive word for letters, and also the label form. Right? They have created a nice label. Less distinctive devices. See, flow designer. The words flow designers mean nothing distinctive, but fortunately there's a small kind of logo created by a combination of tiles. So therefore, though it's less distinctive, by filing evidence or submissions, which they will be able to proceed with it. And here certification marks, that is special marks given to geographical indications and also the companies who are collectively using a single mark to identify their own product which has special qualities. So this is Basmati coming from India, its certification mark. And this is Pure Ceylon Cinnamon Tea logo registered by Sri Lanka Export Development Board. This is filed by Coconut Development Authority. And this is another one in class 11 for kitchen utensils. This is class 37, 44 and 11. In 3 classes they have filed. These are some unique ones which we took to show you. Marks with elements which needs deletions or extra documents. Sometimes when they file these marks, now here there's a Sri Lankan lion logo there. Obviously it's getting rejected because having a label like that here, we won't allow. So we ask, then it's a long process again. We reject it and then you have to come back and delete it and then file amended labels and all that. So avoid that and come out directly with whatever that you need without giving out the unnecessary details which needs deletion prior to acceptance. Sometimes when we reject, you will forget about the application and thereafter there's no follow-up also with the mark. So therefore, we advise always not to file that kind of application. Now here in this bottle shape, this thing, there's a picture of a model. We asked the model agreement to use that picture of the model in this label. So we have to have the copy of that agreement so that it will not create any problem thereafter when we publish it. This model cannot come out and say, no, there was no consent from me to use my picture, my photographs. So this is why we are careful to get down the letter of consent or the model agreement. Now, see the Unilever PLC mark WIM is registered with us in this manner, in these colors. Now see, there are similar ones coming out. These are all public documents, so you can always see. So this is why I'm giving in this presentation. So they're trying to get some, image here with color combinations and letters so that it's getting close resemblance to the existing WIM mark. So it's obviously getting rejected and it's a waste of time of the applicant as well as our time. So we ask them not to do this, come out with unique marks. Now see, this combination is slightly similar to the one that is here, sunlight. So we have rejected this application on the right side, citing this presentation on the label. So if they argue on this, that this is not similar, stating that this is not similar, then they have to file submissions and prove that it is not similar, and they need to submit documents, substantive documents to support their case. Right. Then is another mark, advertising and digital marketing, that is class 35. Even the services can register marks here. There are a few cases I have given here, heard in Sri Lanka, that is gone up to the Supreme Court, from the lower court, High Court, then Supreme Court. This action was filed on the basis of infringement of trademark and unfair competition. I told you there should not be unfair competition. This is called the Smarties mark, where the Nestle was selling Smarties pack in a cylinder shape container. And this other company also came out with a similar mark with a combination of button type chocolates, very popular among children, the Smarties. So they came out with Sweeties, the term Sweeties, and the same kind of container. So it was found to be similar, confusing similar, and I think the case was to grant injunction, so it was allowed because it was found yeah, the second party, the uh, defendant, was trying to copy the mark of Nestle, the Smarties mark. So there's a recent one here, Uswat Confidential Works Limited versus Dainty Limited. That is also Sweet Toffee's case, where the wrapper or the appearance of the wrapper was found to be similar. And the third one here is the Sumit Research, the famous one versus Elite Radio, where Sumit was invented by the Indian company Sumit, and the Elite Radio was the local agent. And the registration was done in India by the original company, but in Sri Lanka, the defendant was trying to register the mark. So it was found it was contrary to honest practices because he becoming being the agent, and while being the agent, he is trying to register the mark here in Sri Lanka. So which should not be the which is not the fair competition. It is unfair competition. So it's violating the sections of the Act. That time it was 1979 Act. So it says contrary to honest practices in industrial or commercial matters under section 142 needs more need more than non-compliance with statutory or common law obligation, but mandated with higher standards of conduct, such as business ethics. This is why we ask people not to copy. Now I will move now fast here to finish the presentation. Now see, this is I told you initially the patent granted to this particular product invented by a doctor that is a local doctor, multifunctional oral cavity mouth gag, and it is used to prevent this to look at to explore the oral cavity and administer medicine to animals. So it can be used on even on elephants. So this patent was granted in 2020, and this is only one example. Now see, when that application is filed, the applicant needs to give the names, titles clearly, and also the claims. These are the most important parts in a patent application. To protect their invention, they have to describe what he is trying to claim in this particular invention. So because there can be other inventions, similar inventions, and you should not be violating the other person's rights, and you should be coming out with clear claims so that your territory is marked here and nobody else can claim that it's infringing their right. So therefore you will proceed easily to the registration without a problem if you claim like this with clear details. Now here what we are given is our details about trademark applications and registration. From this one you can see all those applications that are filed here are not going up to the registration because on the way they're getting rejected due to non-distinctiveness for trademarks, or you're confusingly similar to some other marks, refusals. Therefore, about 20% gets rejected on the way, and only sometimes it's more than 20%, say 30% get rejected, and finally after registration about 70% goes on, and without any opposition, notice of opposition filed, if mark is accepted finally, the certificate will be issued. So these things you need to go through our website to get more details. So thank you very much. I have finished this. I have taken a little more time. Sorry about it. But if you have any questions, and if the host is allowing you to ask questions, I am happy to give answers to your questions.
Yes, thank you very much, Mrs. Ranawaka. That's a very comprehensive presentation covering very important aspects of how to register a trademark or a brand name. we are getting questions from our Q&A option. So considering the time limitation as well, I will take some. Actually, you have already covered some of the
Yes,
points they have
if
raised.
you can mention at least one or two.
Yes, one thing is one company is asking, as patents have time-bound limits, is it more advantageous to get a trademark? Patents have limited time limits, time-bound limits. So is it advantageous to have a trademark?
I'm
Please
here.
explain briefly.
If there are any questions, I'm happy to answer.
You got it?
Fine. Cool.
Can you hear us?
Yes, I'm here. I'm here. Thank you.
Right. You heard the question. As patents have time-bound limits, is it more advantageous to get a trademark?
That's, I think that the party who have asked this question has not understood the requirement of trademarks or patents. Patents means patents are granted to inventions. That is, you invent something new, then you get a protection called patents. So patent is for an invention, product, or a process. Supposing you come out, now I showed you this device used on animals. That is a product invented by that person. It got the patent because it's a unique product invented by him, an original creation. And if he needs to go into the market only, he will need a trademark, which is a different type of intellectual property, right? And then he will have to create a trademark and go ahead with that application to protect it. So patent is given to that invention for 20 years, for 20-year protection, and thereafter no protection after 20 years. But in the case of trademarks, that name will be protected continuously if the applicant, the right holder can renew it for after every 10 years, a renewal fee can be paid. So this is two different concepts, but if they want to know in that manner, patents are time bound. Of course, the invention, the protection, the monopoly expires in 20 years. But in the case of trademarks, it doesn't expire in 10 years if the parties who want to continue with the registration pay the renewal fee and keep it. Whereas patents, it cannot be done after 20 years. That is the crux of it.
Right. So there's another question. Where can we search for world trademarks prior to designing our own trademark? Is there a place?
They can log on to the website of WIPO, World Intellectual Property Organization, global database in which they are sharing the marks, a lot of marks filed world over. So if they can log on to that website, www.wipo, that is wipo.int, int, the same as our website, wipo.int, but we don't publish our trademarks still in our website. What we publish is our directives, notices and all that, and the application forms, whereas WIPO Global Database gives out almost all the well-known marks in the world over, and they can easily, freely log on to that website.
So next question is, if we get registered under NIPO, is it only valid in Sri Lanka?
Yes, that's right. Yeah, that certificate is valid only for the territory jurisdiction, this Sri Lankan territory. And if they want to register or get protection internationally, they have to file an application in the country which they want to get protection. And in the future, I think that also I need to add. There's a system called Madrid Protocol filing. When we are hoping to finalize at least this year that filing system. If that happens, once an application files here, still the certificate is valid only for Sri Lanka, but based on that local application, they can file an international application to register their mark in many countries the world over who are members of that Madrid Protocol. So with one single application, they can seek protection in many countries with that facilitation. So when it happens here in Sri Lanka, that will be facilitated. But when the local certificate that we grant is valid only for Sri Lanka. But based on that, you can always file applications and it can be used as evidence, part of evidence when they try to file applications internationally.
Okay. One another question is when granting approval for a trademark in Sri Lanka, do the IP office consider worldwide marks which are similar for our mark?
Yes, that's what I said. Yeah, well-known marks. We look at our global database, WIPO global database, to see whether an international mark has been copied by the applicant. Sometimes they do that, and if we see a similarity to the international mark that is being published in the WIPO global database, we reject it under a certain section that is called 104.1E, right? So E and F, there are two sections which we can use and reject it because we see a similarity to the international well-known mark.
Oh. And we got another question from our live Facebook page. How to register a slogan?
Yes, slogan also is registerable as long as it doesn't contain a total descriptiveness in the slogan. Now see, look at this, this is butter. If you say, look at this, this is butter, it's a totally descriptive slogan, right? How can it become a registrable trademark? It will not, right? But if they can come out with a slogan which can be recognized as a distinctive mark, it might go up to registration as a registrable mark. So therefore, without having totally descriptive words in a slogan, create a slogan which gives an idea, but without giving directly the idea. Now say, here I will take the slogan on your way home, used by Cargills. Initially we rejected it, on your way home. It's an indication that when you are going back home, you jump into the supermarket and buy your stuff and go. So on the basis of that, we rejected initially, but I think subsequently we accepted the mark because they have kept on using, continue to use it along with the Cargills logo, not only separately. Along with the Cargills logo, they have used it, and based on that, we may have accepted it because it has given a unique distinctiveness by way of long user. So therefore, it has earned that kind of distinctiveness much later. Initially, no, but later they have been able to establish those rights.
And another company representative is asking when will the department allow to do searches, maybe to check the
yes. Yeah, actually now since we are happy to announce that the COVID situation is a little bit cooling down, right? The restrictions may not be, continuing. They will not continue with those restrictions. Little by little, we are going to release our systems here. Therefore, maybe I think we are hoping to from mid-March to allow people to come in by way of, even now people are coming in by getting appointments, but it's limited because we are allowing about 6 to 7 people a day. But if people are really interested in coming in, we have a hotline which through which they can contact us, and also come in separate using better to get appointments, because if you come together, you will be sitting close to each other and it be a risk. Therefore, get an appointment and come, and we'll be opening more for the public from about mid-March.
Oh, right. Thank you very much. Now we have come to the closure of this session, because we use a lot of time, but you have created a lot of interest among the participants. I think a lot of questions are also coming in, but we have covered almost all of the questions, and we will share your presentation as you have promised.
Yes.
Beginning of the presentation. And so I thank all the participants for their participation and having this discussion. I hope they have got a lot of insights into this matter, and more companies can get their trademark registered. And my special thanks goes to our resource person, Mrs. Geethanjali Ranawaka, Director General. Thank you very much, Mrs. Ranawaka, for your time. And
you're welcome. You're welcome. I'm happy to join here, because it's our duty to give information about our work here, so that people can be attracted to this piece, and we have more work then, right? If people don't come here, we have no work. So we have work because of our general public. So we invite people to come and file applications, and we are happy to share information in this manner. Thank you.
Okay, with that I will end this session. We hope to meet you all with another webinar, not the next week after. So until such time, I wish all of you a pleasant day. Thank you very much.